Hello everybody, this is Crypto BitLaw back with another video for you today. This one focuses on the tax implications of staking rewards. But before we dive in, if you like this content, please like and subscribe below and drop us a comment in the comment section. So as we can see here, CoinDesk reported a Nashville couple sues the IRS over Tezos staking rewards tax. The lawsuit could have far-reaching implications for the taxation of staking rewards in the U.S. They say, a couple in Nashville, Tennessee, has filed a lawsuit against the U.S. Internal Revenue Service, the IRS, over tax they paid on rewards for staking on the Tezos blockchain. Joshua and Jessica Jarrett are requesting a refund of income tax paid in 2019, totaling $3,293 for the receipt of 8,876 Tezos tokens, according to a legal complaint shared by a spokesperson for the Proof of Stake Alliance, an advocacy group aiming to bring legal and regulatory clarity to proof of stake technology. The Jarretts are also seeking a $500 increase in tax credits for lost income. This is the first major suit filed against the IRS related to crypto staking rewards. The Jarretts say they should not have been taxed on the Tezos tokens until they were sold or exchanged. Federal income tax laws do not permit the taxation of tokens created through a staking enterprise, according to the document. Quote, like a baker who bakes a cake using ingredients and an oven, or a writer who writes a book using Microsoft Word and a computer, Mr. Jarrett created a property. Just as pastry makers and writers are not taxed on the property they create, but on the income from sales, quote, Mr. Jarrett will realize taxable income when he first sells or exchanges the new property he created, the complaint reads. The IRS has yet to issue specific guidance on the taxation of crypto assets where staking is involved. So as you can see here, we have a copy of the complaint that the Jarretts filed, and it was filed in the Middle District of Tennessee. And it names the plaintiffs, Mr. Jarrett and Mrs. Jarrett, and then the nature of the action. It pretty much kind of lays out a basic overview of what cryptocurrency is, what a blockchain is, what the Tezos blockchain is, how it's built on proof of stake, and it continues to state and allege facts that Mr. Jarrett engaged in staking, he earned the Tezos. It also goes on to state that when Mr. Jarrett filed his taxes, he was charged taxes on the staking rewards that he received from staking on the Tezos blockchain. And it further alleges that the IRS does not have a schema through which to tax staking rewards, and that staking rewards are analogous to property, and that because there was not an exchange or a swap of these Tezos tokens, that it should not be taxed as income. This complaint further alleges that virtual currency is property for the purposes of U.S. tax law, which is true. The IRS came out and stated that crypto was going to be taxed as property. That's why we pay capital gains tax on cryptocurrencies. This complaint further states that new property not received as payment or compensation from another person but created by the taxpayer, is not and has never been income under U.S. federal tax law. The complaint also cites some jurisprudence, in particular this Supreme Court case, Commissioner versus Glenshaw, and states that based on that case, Glenshaw, it requires that an accession to wealth be, quote, clearly realized to be potentially treated as income. And then it goes on to reference the dictionary version, or the dictionary definition of realize, as to convert an asset into more concrete or readily accessible form of wealth in order to obtain the monetary value. So based on that, Glenshaw in particular, a baker would not be taxed solely because he bakes a cake, or a writer not solely because she writes a book or created that property. It's not realized wealth. In order to realize it, you would actually have to sell it or convert it. The complaint does, however, acknowledge that the sale or exchange by Mr. Jarrett of the Tezos tokens he created when staking will be a taxable event under U.S. law. So to summarize it, in one of the final paragraphs of this complaint, it states, in summary, neither the Internal Revenue Code, regulations, case law, nor the Constitution permit the treatment of created property as income. Therefore, consistent with over a century of federal income tax law, the property created by Mr. Jarrett is not income to the Jarretts until such property is sold or exchanged. And I mean, they make a pretty compelling case, based on everything that was set forth in this complaint. The IRS code, jurisprudence and the facts of this case, I think that the plaintiffs make a pretty good argument that the Tezos staking rewards are not taxable income, at least until they sell or exchange. So you can see down here in the prayer for relief what the plaintiffs are seeking. They want a judgment that the disputed federal income taxes were erroneously assessed. They want a refund for the 2019 tax year in the amount of the assessed taxes for the staking rewards. They want the cost of bringing the action, including the attorney's fees, and then the catch-all, any such award that the court would deem just and proper. So here's the website for the Proof of Stake Alliance. It's the advocacy group that ultimately funded the Jarrett's litigation against the IRS. And we can see here the board of directors. There's a president and founder of Tezos, some lawyers, a lawyer, a businessman, and then a COO, CFO of Polychain Capital, so a VC fund. So we can see here on their website the initiatives of the group, and they want to address the tax treatment of staking rewards, saying that they want better treatment of taxing of staking rewards, and these issues must be dealt with before the effects of poor policymaking are felt. So pretty much by filing this lawsuit, they want to establish jurisprudential precedent of how staking rewards will be taxed before policymakers set any sort of law on it. So they want to kind of jump the gun on that and get in there and get some sort of legislation from the bench, as it's commonly known. They want to adjust KYC, that's Know Your Customer, and anti-money laundering requirements. They want to address comprehensive crypto asset regulation, and they want to preserve decentralized open blockchains. Now, earlier on, we addressed that the IRS treats cryptocurrency as property for tax purposes, and here is a copy of the notice that was released by the IRS in 2014, pretty much outlining the schema and the framework under how they would tax cryptocurrencies. You could do a deeper dive into this document if you want. It's going to be linked down below in the description. So as you can see here, this is a copy of the docket for the case at bar, Jarrett versus the United States, and it begins here with the complaint being filed on May 26 of 2021. And the only real entries of particular importance are this one that occurred on October 6th, where it set a discovery deadline by March 18th of 2022 and a motion deadline by August 18th of 2022. And then there's also an order setting the case for a bench trial on March 7th of 2023. Now, one of the things that really struck me as interesting was the date that they set this bench trial for, March 7th of 2023. That's almost 2 years out, and it seems like if I had to opine on the reasons for such a late trial date, to me it appears that the court wants to let this issue resolve itself in the legislative branch. If the court were to rule on this, they would essentially create legislation from the bench, as it's commonly referred to. When a court rules on something and then issues an order in a domain that should be normally dealt with by the legislative branch. So you have judge-made law that's issued from the bench. Normally this type of thing that's a public policy or tax-related issue should normally be dealt with by the legislatures. So perhaps that's one of the reasons, or the main reason, why this bench trial was set so late, to give these issues times to work themselves through the legislative branch and have the actual lawmakers issue some sort of guidance and rulings for how this should be dealt with. So there you have it. That pretty much wraps up this video for now. We're going to keep you posted if any new developments happen in this case. You can kind of check back regularly to see the updates. We'll be sure to cover this in detail as this case develops further. As always, none of this is intended as legal or financial advice, and please, if you like this content, be sure to like and subscribe and drop a comment down below. We really appreciate that. Also, follow us on Twitter. We are at CryptoBitLaw. Thank you. We'll see you on the next video.